like to welcome you area, and I will be your moderator for this evening's program, which consists of two forums. The first forum will be candidates for the office of Judge of the Superior Court, office number 5. And we have here, in the order that they chose by lots, is Paul Cullen, Chris Kobe, and Alex Serrell. Thank you. And the second forum will be with candidates for Judge of the Superior Court, office number 7, and we'll start that one at 8 o'clock. The League of Women Voters of Los Altos Mountain View brings this forum to you. Our co-sponsors include the League of Women Voters of Palo Alto, the League of Women Voters of Cupertino-Sunnyvale, and the American Association of University Women for Los Altos and Mountain View. The League of Women Voters is a nonprofit, nonpartisan organization interested in the informed participation of citizens in government. The League never supports or opposes any political party or any candidate running for public office. Information about and opportunities to join the League are available in the lobby outside the door. Voter information from the League and the candidates' responses to the League of Women Voters questions and campaign literature from the candidates themselves are also available in the lobby, and please pick up information on your way out. For more information about tonight's candidates and for voter information on all of the races and ballot issues, please check the League of Women Voters nonpartisan election website, www.smartvoter.org. This evening's forums are being taped by Mountain View Public Access Cable, KMVT, for broadcast on 11 a.m. Friday and 2 p.m. on Sunday. Please check the KMVT schedule for additional times. The tape will be made available to other public access channels for public viewing. So I'm going to go over the format and rules of our forum tonight. The forum will open with 3-minute opening statements from each candidate, and the speaker order has been chosen by lot. A timekeeper will signal when 1 minute remains and when 15 seconds remains. And if you can please note where you are so candidates can see, and a stop sign. Okay.
Thank you.
After the opening statements, we will have the candidates respond to written questions from the audience. So please raise your hand if you have a written question or need a card to write a question for the candidates. And our question sorters and collectors are on the side here with the big League of Women Voters buttons on them. Each candidate will have 1 minute to respond to each question, and you will get a 15-second warning and then a stop sign. The order of speaking for answering the questions will rotate, and we'll try to answer as many written questions as possible within our time frame. At the end of the question period, each candidate will have 1 minute for a closing statement, and throughout the forum, our timekeepers in the front row will signal the time. I'd like to remind the audience that there will be no applause until the end of the forum, and I'd like everyone to please silence your cell phones now, if you could, please. Now for our first of the evening's forums, I'd like to introduce the 3 candidates running for Judge of the Superior Court, office number 5. They are Paul Cullen, Chris Kobe, and Alex Serrell. Candidate Cullen will start the 3-minute opening statements from our candidates, followed by candidate Kobe and Serrell. So, Mr. Cullen.
Thank you. Thank you to the League of Women Voters for holding this forum, and thank you to each and every one of you for coming out on an evening to participate. Running for judge is a little bit of a mystery to many people, and so forums like this are, I think, essential to help voters make an informed decision. Judges run county-wide, and they serve county-wide. Very few other offices are county-wide. And I'm Paul Cullen. I'm a deputy district attorney. I serve you now. It's an honor as a criminal prosecutor in the DA's office. It's my second career. I didn't even go to law school until I was 35. Prior to that, I had a career in business, most of it in high tech. I put myself through school. I come from a background, very hardworking family. My dad worked 2 jobs, that sort of thing, from the East Coast. worked in a variety of different jobs, but ultimately spent 9 years in the high-tech field. Some of the companies were startups. They were on the East Coast. One of the first lessons I learned when I moved to the West Coast was startup means something different to the folks out here than it does to the East Coast. So I didn't strike it rich or cash in big stock options, but I was always interested in the law, and I was always interested in having government actually work to help people. And so that's how things have worked out for me. For 19 years, getting close to 20, I have served in the DA's office. I've handled a range of cases. I've worked in the South County office, but mostly in the main office in San Jose. Those range of cases include driving under the influence, drug trafficking, assault and battery. But I'm probably best known for two things. As a fraud prosecutor, for 10 of my 19 to getting on 20 years, I've done a variety of fraud cases, mostly elder fraud, real estate fraud, and now currently loan modification fraud. In between my stints on the Economic Crimes Unit, I've handled cases of sexual assault and a special category of cases against sexually violent predators, men who have a pattern of sexual wrongdoing, are mentally ill, sexually deviant, and present a range of danger. But I've also worked in our courts, where we call them collaborative courts, where we try to provide services to nonviolent drug offenders and the mentally ill so that we can break that cycle, give them medication, housing, and social services so that we actually can get people back to productive lives. I'm the only candidate endorsed by the judge who is retiring, Jerome Brock, and a total of 45 current and retired Santa Clara County judges, the sheriff, 11 police officer associations, 50 elected officials from all across the county, 100 attorneys, 7 county bar presidents. They're all listed on the piece of literature that I would invite you to pick up. The front has a little summary of what I've said, and the back has a partial list of my endorsements. The website has many more. And I think what's critical is that I bring something different, and that's the life experience of having worked in business, as well as a range of experiences as a prosecutor. I hope we can delve into more as the questions come up this evening.
Candidate Kobe.
Thank you very much. And I also thank you all for being here this evening. It is an honor to talk to each of you. I hope you'll pick up my flyer outside and also look at my website and the Smart Voter information. I'm a native Californian. I came to the county for the first time in 1969 when I transferred to Stanford as a student. I graduated from Stanford and went to UC Davis King Hall School of Law. My wife and I then settled in the South Bay, and we have been here approximately we've been married for 40 years. Our daughters were born in this county, and they both graduated from high school in this county. One graduated from college in this county. I started my career in the Los Angeles County District Attorney's Office and then transferred to the San Mateo County District Attorney's Office. I've handled a wide range of cases during the time I was a Deputy District Attorney, including a case of murder during the period of time I was only 3 years out of law school. My legal experience includes not only criminal law, but also 2 other areas of the Superior Court's responsibility, which is civil and juvenile. One of the things I've done outside my practice, you might say, is to volunteer as a court-appointed special advocate, as a person advocating for at-risk youth. I was trained in Milpitas for this, and I was sworn in by a member of this court. And I've spent several hundred hours working with disadvantaged youth in that capacity. I have broad legal experience which has been evaluated by the other lawyers. That is to say, I've been evaluated by Martindale-Hubbell, and for more than 25 years, I have received the highest rating for legal ability and for professional ethics. During my time as a lawyer, I've also been identified as a super lawyer for Northern California in the field of employment litigation. Outside my day job, I have volunteered, as I said, as a CASA, but I've also volunteered in other circumstances. For a city council in which I served as mayor for 2 terms. I've served on a planning commission, which I've also chaired. I have served on a county civil service commission. And as an attorney, I volunteered to lecture at San Jose State University, Mission College, UCSC Extension, and Lincoln Law School, where I co-taught a course with a member of the bench. I have been endorsed by the San Jose Mercury News, the Santa Clara County Bar Association, which has approximately 2,500 members. I think that endorsement is significant because the Bar Association includes not only attorneys, but also current and former judges, both state and federal. I have also been endorsed by Congresswoman Anna Eshoo, State Senator Joe Simidian, and State Assemblyman Rich Gordon. I appreciate in advance the attention you're going to pay to our statements and our questions. Thanks.
Thank you, Mr. Searle.
Thank you, everybody. My name's Alexis Searle, and for the past 16 years, I've worked at the Superior Court. I work side by side with the very judges that we are all seeking to become. I am the lead research attorney at the Hall of Justice. So this means that I work behind the scenes with the judges, analyzing the cases, reading the pleadings, sitting in the courtroom and listening to the evidence, and then going back in chambers and figuring out what was really shown, what was proven, what would justice require under those facts. I help write the statements of decisions. In my time with the Superior Court, I've worked on every imaginable variation of cases that you will see in criminal law, everything from traffic infractions to death penalty, habeas corpus to coram nobis, motions to suppress, motions to dismiss, anything that a judge would want help with. My unit of 4 people is there to assist the judges. And it's a small unit. We are not clerks in the sense that we are assigned to an individual judge. We are central staff, and the judges come to us only for the most important and most high-profile and significant cases. And so I've had the wonderful opportunity to work on the most interesting cases at the Superior Court over the past 15, 16 years. Maybe a way to explain it is to tell you what it looks like on TV, and then tell you how it's not like that at all. We all have seen Law and Order, and there's almost always one of those scenes where the attorneys are in chambers with the judge, and the district attorney will say something like, "Your Honor, our prime witness is receiving death threats, and we want to get that before the jury in order to show the defendant's consciousness of guilt." Or the defense attorney will say, "Your Honor, my client's rights were violated when the evidence was seized, and I want to move to suppress." And on TV, what'll happen is maybe they'll say the name of a case, and then the judge will say, "Motion granted" or "motion denied." And it's not like that at all. I'm sorry, TV does not tell you the whole story. Those decisions that the judges make are the most important decisions that judges do. They take a great amount of time and research. You actually have to read the cases. Nobody knows them all off the top of their head. I know many of them based on my many years of experience, but still it takes a lot of hard work to come to the right decision. And that's the expertise and experience that I bring to the bench. I have never been a paid advocate. I have always worked for justice and impartiality and unbiased. That is who I am and what I represent and what I stand for. Thank you.
Thank you. We will now start the 1-minute response to questions from the audience. And the first question will have Mr. Kobe go first, followed by Mr. Searle and Mr. Collin. The first question is, how will you vote, and what is your position on the November initiative to end the death penalty and amend the 3 strikes?
This is one of those questions that we get all the time from voters, and one of the most frustrating things for the voters, and one of the most difficult things for us to indicate, is that under Canon 5 of the Canons of Judicial Ethics, neither judges nor candidates for judge are allowed to express an opinion about an issue which may come before them as judges. It's extremely frustrating because what this means is, for the questions everyone wants to know, what's your position on the death penalty? How do you feel about same-sex marriage? We can't do that because of the independence of the judiciary. The person who is elected judge is supposed to go into the office with no expressed opinion as to the issues which may come before him or her. And for that reason, we can't, at least as far as I'm concerned, I cannot express an opinion.
Mr. Searle.
And that really nicely summed it up. You probably have all seen the Senate confirmation hearings for Supreme Court justices, and the Senate members will ask them the hard questions like that, ask them their positions on things, on the hot button issues. And it is frustrating to watch the justices, the appointees, shuck and jive and dodge the questions. But that's what they have to do. That's what we have to do. And that's because it's unseemly for a judge or judicial candidate to have prejudged an issue, to have expressed an opinion on it before it has come squarely before the court in a way that the evidence is set up and properly presented. Not allowed to prejudge the matters. And asking for positions on questions like that, it calls for that. So none of us are going to be able to answer them. I'm sorry.
Mr. Collin.
Thank you. What I will add, because I am in agreement with the other two candidates, is that I've also equally gotten the question about medicinal marijuana as often as I have gotten the question about the death penalty. The rationale behind Rule 5 of the Code of Judicial Ethics, which applies to judicial candidates as well as sitting judges, is that judges need to essentially leave their baggage outside the courtroom before, during, and after the pendency of a case, so that when you come into a courtroom, you know that I will be doing my human best to be objective and apply the law as I interpret it and as it's presented by the attorneys to the facts of the case before me. Judges can speak about issues if they deal with the administration of justice, and so we can talk about things like procedure and making things accessible to the public at large. But I agree that the specific questions, the way you would ask a legislator, are not questions that a judge candidate can answer for the reasons that I and my fellow candidates have described.
Thank you. For the next question, we'll go Mr. Searle, Mr. Collin, Mr. Kobe. And we have a few questions here on budget. How do the courts successfully function where possibly severe budget cuts may be done?
A very timely question. Well done, whoever submitted that one. It is very difficult, and the budget situation is getting drastically worse as we speak. There are going to be enormous cutbacks, and it frankly will result in diminished access to justice for the public. There's just no way around it. There's always a tension between time, money, and justice. If we had enough money, then we would have enough time to fully implement justice. But without the money, either the time shrinks or the justice shrinks. We'd like to believe we're not going to make mistakes when we rush through things because of the budget crisis, but unfortunately it will happen. It's a horrible situation that we're all entering. These are difficult times.
Mr. Collin.
Thank you. So in the last 3 years, the state of California has reduced the judicial budget by something approximating $460 million, and it has been proposed that it will be in excess of $500 million in this next fiscal year. Justice delayed is justice denied, and this will delay justice and access for individuals. Court constructions will stop if they haven't already. Fees for many people will go up. And the concern that those of us in the justice system have is that we're not talking about stopping one program or one agency, but perhaps a branch of government, a branch that our 3 branches of government require so that we have a civil society of laws. In our California county courts, Santa Clara County courts, we have a number of programs that are dependent on additional funding so that we can provide those services I mentioned in our service-oriented courts to try to break the cycle of crime. And if that is delayed, it will really be a tragedy because it will cost us more money in the long run. We need to be smarter, but that proof is in the pudding.
Mr. Kobe.
Yeah, as you can tell, all 3 of us are concerned about this, and the members of the court will have to be particularly innovative in making the very hard decisions as to how justice will, in essence, be cut back. Certain statutes require that certain cases be given priority and be treated within a certain time period, and many of those are in the criminal system. What this means is that for those people bringing civil cases, lawsuits for money, these cases will probably be denied. And I think there is a fundamental unfairness to that, just in the economics that will be applied there, is it'll take longer to get to trial. It'll take longer to resolve a dispute. And what could happen there is, for those who can afford it, they can go to an alternative justice system, to an outside mediator or arbitrator to see if it can be resolved. But for those who want a trial by jury of their peers for civil cases, it is not going to work.
Thank you. For our next question, we'll go Mr. Collin, Mr. Searle, Mr. Kobe. Okay, following up on the budget, the May revise has clobbered the courts financially. The Santa Clara County Superior Court's reserve will go, and our new family court will not be built. What kind of innovative ideas do you have for dealing with this financial crisis?
Well, that obviously is part two of the question that we've just been discussing. For one thing, we need to preserve the federal grant funding. Many of the service-oriented courts are still surviving because of federal funding. And we also need to see if there can be some sort of private-public partnership so that in the way of charitable work, perhaps that money can be funneled into the criminal court systems that may not have been done before. Clearly, the businesses in our communities are benefited from a thriving justice system, just as any of us are in our normal walk of life. So I know that the courts have done a good job in Santa Clara County of weathering the storm by anticipating as much as 10 years ago the potential decline. And so the loss of personnel in the court system has been more by attrition than the kind of dramatic layoffs you've seen in San Francisco or Los Angeles. And I would hope to work with the judges, and I'm proud of the endorsements I have, to try to work with that group of people to continue that kind of forward thinking.
Mr. Searle?
Yes, as a court worker myself, I've lived through this as the budget gets worse and worse and worse. And under the leadership of Kitty Tori and then David Yamasaki, our CEOs of the courts, they have been able to keep us open, unlike the San Francisco courts, only with a few days of furlough. And what that has enabled is that we really haven't seen the brunt of it yet. And what they have done is they've not filled spaces. So instead of firing people, as people leave, they leave it to the people who are still there to do more. And we are doing more with less. The good news is I was having dinner with, I sat with David Yamasaki last night, and he said that there is still hope for the Family Justice Center. It is not written off yet. So it's possible that we still will have that very needed new courthouse.
Yes, Alex and I, well, all three of us were at the same dinner last night, and I spoke with the presiding judge about the family court building, and I think it will be, he said it may be delayed, but it's still possible. It's an ambitious undertaking to consolidate all the family court services and related agencies under one roof, and it's something that the court has worked on for some time, and I hope it can be saved. The idea of a public-private partnership, I hope can work out, but I'm a little bit worried because it brings to mind to me naming rights for stadiums and things like that, and I don't think we can do that with our justice system. I'm sure we can get around it. This court is going to have to rely more than ever on the county bar and its members to step up to the plate and to provide the services that are necessary in a time of increasingly unavailable courtrooms. Santa Clara has been prudent in managing its resources and also in building a reserve. And you can understand, we'll talk about it later.
Okay, thank you. For the next question, we'll go Mr. Kobe, Mr. Collin, Mr. Searle. What do you see as the greatest obstacles to defendants receiving speedy trials, due process, and justice? Easy question, right? Mr. Kobe.
Okay. The obstacles there, I think, are primarily going to be economic, but as I said earlier, the statutes require that certain cases be given priority, and many of those are in the criminal field. So I think that realistically, within the context we've been talking about, the criminal courts will be given priority because they have to be given priority, because that's one of the court's primary goals, is to manage crime and try people and get them taken care of in terms of the cases that come before them. So if there is a priority in the budget crisis that we face for the courts, the criminal courts, I think, will be taken care of.
Mr. Collin.
Well, just within the last year, our court system has managed to fund and staff the arraignments, which are the first time that a criminal defendant comes to court, so that they have immediate access to an attorney. Up until then, they did not, which resulted in repeated trips to court, or worse, actually, someone perhaps not getting the full benefit of their legal rights. You also need to hold your district attorney's office, people like me, accountable, so that we are bringing cases that should be brought and not bringing cases that should not be brought. And I'm proud to say, I think if you ask about me, you'll see that I've tried to do that in my own work. I think what's essential, although justice delayed is justice denied, and defendants have a right to a speedy trial, it's really more essential to get it right than it is to get it done fast. And that means good lawyers helping defendants exercise their rights. You have in your county a national model for the Office of the Public Defender, whose leader was just appointed to the court, by the way, by Governor Brown. And so it's really going to be incumbent on making sure that you can continue to have a fully functioning DA and public defender's office, and then support the private bar so that they can offer their services.
Mr. Searle.
Well, certainly, as my colleagues have mentioned, there's the budget issue, which we have already touched upon, but also a danger to due process and the defendant's rights is bias within the system. Many defendants come from different socioeconomic and ethnic backgrounds than the judges and the many players within the system. And that's a danger to them. It is statistically proven that the death penalty is more frequently imposed upon persons of color, and so too many drug sentences are more severely meted out to minorities. And that's an enormous danger, and what is required to prevent that is somebody who comes to the system with a background of impartiality and being unbiased, and the experience of having analyzed the cases with that in mind, like myself.
Thank you. For the next question, we'll go Mr. Searle, Mr. Kobe, Mr. Collin. The next question is, can you please discuss your view on the appropriateness of instructing juries on the right to disregard bad laws and jury nullification? Mr. Searle.
That is going to fall under the Canon 5, because it's asking about an issue that does sometimes come up. Jury nullification is one of those sort of hot button issues. Certain people believe strongly in it, and it does exist. The present state of the law does not require that juries be told about it. And beyond that, I'm not at liberty to say a personal view. I can only tell you what the law is at the moment. And the law at the moment is that there is no requirement, in fact, it's discouraged, that a jury is told about that.
Who's next?
Sorry,
I am.
I wasn't sure
Okay,
if it was
sorry.
me or Chris.
Mr. Kobe, yes.
I agree with Alex.
Great. Mr. Searle. Oh, no, Mr. Collin.
I'll go again.
I actually think that it is an issue that can be discussed because it is the current state of the law that jurors are not to be instructed on the right of nullification. We get our laws not only from the laws that are written in the statutes by the legislators, but by laws as they are interpreted by judges and appellate courts and published in what we call the case law. I instruct juries on a regular basis. I've fed the 46 jury trials. I'm on the trial calendar now in my day job. And it is not uncommon for the defense to ask that jurors be given the right of nullification. That issue of saying that a law should not apply or it's a bad law, the concept is that that's what your legislators are for. And the state of the law in California is that juries should not be instructed on nullification, but rather they should apply the facts of this case to the laws and elements that the prosecution has to prove in a criminal case. And that's the current state of the law.
Thank you. For the next question, our order will be Mr. Collin, Mr. Searle, Mr. Kobe. What, in your opinion, I hope you all can answer this one, have been the most egregious miscarriages of justice in our court system, and why do you believe that?
Well, the most egregious effects in our court system are when an innocent person is found guilty and suffers the consequences of sentencing. We have had a number of those, and there's a recent study that came out that looked at it nationwide. The current Office of the District Attorney has a criminal conviction integrity unit, which is essentially quality assurance for our office, handled by someone in a higher level of management. And as a district attorney, I am grateful for that, and I would encourage defense attorneys to challenge me when I bring my cases. If you will, double check my numbers, not to be lighthearted about it. And I want appellate courts to review it as well, because I'm not in the business of getting wrongful convictions. I'm in the business of seeing that justice is done. And I want that to be double checked appropriately under the law.
Mr. Searle.
Certainly, miscarriages of justice are the greatest are an innocent person being convicted. And as an employee of the court working with the judges, we are always on the lookout for that sort of thing. The DAs are bound by a case called Brady versus Maryland, which requires them to bring forward any favorable evidence for the defense. And often the court is asked to weigh in on whether information should be disclosed to the defense, because individual district attorneys will think, no, this isn't such a big deal, I don't need to give it over to the defense and let them know about it. And the courts weigh in on that. Also, and we are ever vigilant. It is one of the deepest and most significant duties that we have at the court. And also, we have caught things on our own that nobody else has caught, and that's always a good feeling to find something and to make sure that justice is done.
Mr. Kobe.
Thank you. I think all three of us agree that the worst miscarriage of justice is the conviction of an innocent person. The comment I'd like to make is to let you know that the sort of cutting-edge area for judges, I think, is the identification of implied bias. It's not express or explicit bias as we used to have in previous days. It's where people, acknowledge or flaunt the fact that they're going to treat somebody differently because of a stereotype or because they're in a protected category, or I would never vote to make that for a verdict of innocent for a person like that. What's tougher now is for each of us, and whichever one of us becomes a judge is going to have to address this question, to acknowledge the fact that we each have implicit biases, ones that are unstated, ones that are even unconscious. It's a concept that is not easy to wrestle with. I certainly had a difficult time with it. But studies have indicated that we all have these biases.
Thank you. For the next one, we'll do Mr. Kobe, Mr. Collin, Mr. Searle. The justice system is a remarkably expensive process for litigants. Can you suggest ways for opening access to the justice system to all citizens? Mr. Kobe.
It's open. It is a matter of cost. One of the things that was recently implemented, it started last year, was the expedited jury trial. There are those who feel that they would like to have a jury of their peers, and they would like to have a jury trial. And now you can do so if both sides agree. You can have an expedited jury trial, meaning it's going to be one that takes place in one day. So in a sense, it's how much justice can you afford. But I agree with the implication of the question. To protect rights, especially in the civil field, is expensive. And to make sure that we do it right, carries quite a cost. So to be 95 or 98 or 99% sure that we are correct carries a disproportionate cost, and we'll have to explore other ways to see where we can save, but the expedited jury trial is one idea.
Mr. Cullen.
Another idea is people going to small claims court. I've sat as a temporary judge, as a volunteer in the evenings in small claims court. Lawyers do not appear to represent individuals. But the first thing that I have to do when I take the bench is make sure that someone who is in small claims court is not giving up their rights that they might have in superior court, where it might cost them more money, because in small claims court you limit what you can get, generally to $7,500. So how do those people get what they might want in superior court? Generally speaking, they probably need the help of a lawyer. And there's been a lot of discussion about whether lawyers should be required to provide a certain amount of pro bono or free legal services. Many lawyers do. There's also a lot of work in the local law schools, actually across the nation, to try to provide some level of legal service. And there's been discussions about whether there ought to be national models as well. Really, quality law, like quality everything else, does cost money. And I think that the real solution to that, like many of the questions that are being asked, is more of a broader societal question that can't necessarily be solved just by the courts.
Okay, thank you. Mr. Searle.
Well, in the criminal system, cost is not really an issue because the defendant is dragged in unwillingly, and if they don't have the money for an attorney, one is appointed for them. We've all heard the Miranda rights on TV also. So there's not too much savings that can be done there. But in all the other areas, there are ideas that can work. For example, mediation, which involves just plain trying to work it out. And collaborative practices exist, especially in family courts. Instead of both the husband and wife getting an attorney and paying those attorneys all the money to go into court and fight it out, there is a method by which you just pay one attorney to mediate and collaborate and figure it out, and it's an enormous savings, and it really brings the parties together. It's much more healthy in the end for the entire family.
Thank you. I know it's hard to answer a question in 1 minute, but when that little buzzer goes off, you have to stop. Those are our rules. So anyway, the next question will have Mr. Searle, Mr. Kobe, and Mr. Cullen. Detention facilities are crowded. Can you discuss what role the judiciary can or should play in this issue through penalties or alternate settlements?
We have something that recently was passed into law called realignment, which means that we are going to seriously have to address these questions. And there are sort of three categories of defendants. There's the low-level drug offenders, petty thieves, who we already deal with outside of the prison system and mainly outside the jail system through treatment courts. There's the dangerous and violent felons who there's no option, but they have to go to prison. But there's a middle range of individuals who presently are going to prison, but maybe they should be brought down into the collaborative courts and the treatment courts. And that is something that judges can and should implement.
Mr. Kobe.
Yes, because of the realignment that took place last year, the major change in criminal sentencing, many more individuals who are now in prison are going to be sent to county jail. And there, the judges are going to have to be particularly innovative and understanding in figuring out exactly what resources can be applied to each person, whether the person, as Alex says, needs to be incarcerated, but if they have, for example, a substance abuse problem, how that can best be treated. In the past, when I started, it seemed like the attitude was lock them up and throw away the key, and we see how many people have been incarcerated in the state of California. Now, for budgetary reasons and perhaps others, we have to ratchet that back, and courts and judges will be called upon to use their best skills and their greatest innovation to make the best educated guess as to the best way to treat these people who are being sent back from the state prisons.
Mr. Collin.
What realignment means is that effective in October of last year, the biggest change in felony sentencing law in 35 years took effect. The effect of it will be that, as has been mentioned, many more people will be kept locally, either in jail or in the community, that previously would have gone to prison. Judges are not magicians, and we don't make up the sentencing options. Judges apply a range of options, a menu, if you will, that's been established by the legislature. We look at factors involving the person, the crime, and potential services that are available. And we rely on the probation and parole departments and the defense attorneys to tell us what the needs of the client are and what services are available. And we pick and choose from those options. We're still trying to figure out which services work. It's called evidence-based sentencing. And so we're in a new phase, and hopefully judges will find a way to make the limited options work.
Thank you. Next question will go Mr. Collin, Mr. Kobe, Mr. Searle. Have you read Professor Michelle Alexander's book, The New Jim Crow, regarding the impact of racism in the criminal justice system? And if so, can you please comment? And if not, can you please comment? Trick question there. Mr. Collin.
I have not read that book, but I agree with Mr. Kobe that the issue of inherent and implicit bias is something that judges and everyone in the system needs to be mindful of. I will say that of the many books that inspired me to be a lawyer, one is, the one that most affected me was Deadly Force, a book written by a man named Lawrence O'Donnell Jr., whose father represented an African-American woman and sued the Boston police force for wrongfully killing her husband. It was a clear act of clear racial discrimination, and it was the first time that someone victoriously won a case of wrongful death against a police department in a city. I think that the issue of racial discrimination in our courts is reflective of racial and socioeconomic discrimination in our society. And again, I think the courts need to be part of a solution, but cannot conjure up a solution on their own without the help of everyone else.
Mr. Kobe.
Discrimination is the area of law in which I practiced since 1979. I have read approximately 10 pages of that book. So I've read a little bit of it. I certainly haven't read anywhere close to it. The point the author is making is that racism is alive and well in this society, and that because of the prosecution of African Americans, a great proportion of black individuals, especially males, have been disenfranchised because of their criminal convictions, and the effects are not only in voting, but in employment. That is what I understood to be the thesis of the book. I have worked in that field, and it's been fascinating to me to understand the laws regarding discrimination and how people deal with people who are not like themselves. And that's one of the biggest challenges I think any judge has in sentencing and dealing with people who come before him or her. And that's one area where I think I have a great deal of experience.
Mr. Searle.
No, I have not read that book, but I do understand, as in fact I touched upon a little bit earlier, that there is bias within the system. It's very unfortunate, but it's statistically proven to be there. And we all will work to fight against it, both internally and within the system. And there are classes to be taken, there are books to be read, and training, and to really bring that to the front of your mind when you're dealing with individual cases. So that book I'm not familiar with, but a book that is formative for me is Kamala Harris's book called Smart on Crime. And its main thesis is that we all want the same thing in the criminal courts, which is to make society safer. And that's not done or achieved by a knee-jerk lock-em-up reaction. If we can give people treatment and programming so that instead of just punishing them and making them more angry, they will actually learn and become better, that's the best solution for everybody.
Thank you. For the next question, we will have Mr. Kobe, followed by Mr. Searle and Mr. Collin. Can you express an opinion regarding the growing trend toward privatization of prisons and other detention facilities?
Well, I guess that might fall under the heading of process. I am leery of the privatization trend, and I'll tell you what immediately comes to mind is one of my greatest loves, libraries. And the trend towards privatization in libraries is one that I don't think is necessarily positive. In terms of incarceration, I can comment about what I have read, and I know that there are problems with the privatization. Does it save money? I assume it does, because elected officials vote in favor of privatizing correctional facilities. Is that a good idea? To me, as a policy matter, one has to consider how much control the society and the organization, the entity, the county, the city has over the correctional process. All levels of government are looking to save money, but some come at too high a cost.
Who's next?
I thought it was Mr. Searle, but I'm happy to go next.
I'm trying to, yeah, Mr. Searle.
Okay.
Sorry. Trying to keep my numbers
The problem with privatization is it's actually been called, it's been suggested that we have a bit of a prison industrial complex. And that it means that if it becomes a money-making adventure for various businesses, then they will have an incentive to keep it going, and they will not have the incentive to actually help or treat anybody. If they make their money by warehousing people, they will pay their lobbyists to encourage the government to pass more laws, to put more people in prison so that they could make more money. And that's a very real concern, and one that we have to be extremely aware of and institute safeguards to prevent if there is going to be any sort of privatization of incarceration.
Mr. Collin.
Well, I think of the white pages, the yellow pages, and the blue pages, the pages that had the government agencies, in the days before Google, when we actually looked things up that way in the hardbound books that were left on the doorstep. I'm leery as well of privatization of incarceration, although I see every day in the caseloads, or at least when I was working in the collaborative courts, that private providers of individual services can provide services to people more effectively or more efficiently than the government might. That worked because they were held accountable to the court system and the probation department. In general, I think what we need in government and programs that benefit the community is accountability and openness. And the concern I have with privatization at that large scope of incarceration is that there may be difficulty maintaining accountability and openness. But there's a place for it on an individual basis if we maintain accountability and openness.
Thank you. I think we'll do one more question and then have your closing statement, since it's now 5 minutes to 8, unless I think we could do 2 more. Yeah, because we have another forum. So this one will have Mr. Searle, Mr. Collin, and Mr. Kobe. What have been the most critical judicial decisions made recently, and why do you think so?
Recently, from the U.S. Supreme Court, there was a case called Padilla versus Kentucky, and it involved a person who was convicted of a crime, nothing big. I don't remember what it was. It might have been a smallish drug crime or a property crime. I don't think anybody was hurt. And the result was that Mr. Padilla, after he served his sentence, after he did his time, that of course he should have, then he was deported. And he was never told that that was going to happen to him. And this case set forth the new rule of law, which states that when a person is facing adverse immigration consequences, that must be taken into consideration. The attorney representing the defendant must tell him about it, and they must plan about it, and they must try to mitigate it if possible.
Mr. Collin.
I'll just add, Padilla actually lived in the country for 20 years and had served in the military, and the crime was trafficking drugs, but that's certainly one of the most significant, because the concept is that the penalty for the crime shouldn't also include the complete end of your life in the United States. without you knowing about it. So I will add to that, though, the cases that are dealing with equal rights under marriage. And while I will not be able to tell you how I would rule in a particular case for reasons that have been discussed, we do have cases that have been ruled on by both the California Supreme Court and the United States Ninth Circuit that are making their way through the system. And they raise compelling issues of what discrimination means in the year 2012. The forefront of civil rights appears to be the rights of equal marriage for the gay, lesbian, bisexual, and transgender community. And so I actually think you might find that case, if you haven't already read it, to be remarkably readable to the average public, and it really puts in the forefront civil rights.
Mr. Kobe.
Just to give you some variety, I'm going to choose a civil case, Citizens United. I have been an observer and sometimes a participant in the governmental process, and I have always been interested in the aspect of money in politics and how it can affect our elections. The decision 2 years ago, written by Chief Justice Roberts, I think, was a fundamental change, every bit as important as realignment in the criminal field, because it goes to the function of government and elections and how we choose our elected representatives and what kind of speech we have and how loud that speech can be, and to what extent, for example, corporations have free speech rights. So I have my own bias there, and that is, I think that case is extremely important. How that will turn out, how it will be evolving, I do not know, but it goes to the very function of how we choose our elected leaders.
Thank you. Okay, we will now end with the 1-minute closing statements from each candidate, and we'll start with candidate Kobe, followed by Mr. Searle and Mr. Collin.
Thank you again for coming here tonight. I know you have a finite attention span, and we're, of course, anxious to tell you everything we can about ourselves. The only additional things I'll tell you about me is that I performed the function of a judge for several years as a temporary judge handling substantial civil cases. I have also served as a judicial arbitrator, writing decisions which, when they have been accepted by both sides, and a few of them have after I've written them, have become judgments, and those are essentially the functions of a judge in the Superior Court, and I've been performing them for several years. I would also point out my experience not only in Santa Clara County, but being in private practice in the Superior Courts throughout the Bay Area, in Northern California, and also Southern California. My experience also includes the federal courts as well as the state courts, and it includes appellate work as well as trial work. Thank you for your attention. I would be honored to have your vote.
Mr. Searle.
Thank you very much, everybody. I appreciate it. I had a nice time here tonight. What is the most important thing that you want in your judges? We've touched upon some of it with the questions. You want them to be unbiased. You want them to be experienced in the law. You want them to come from a background that enables them to identify with the people that come before them. And that's why I entered the race. I am proud to be the only candidate who has not been a vigorous advocate for a position before the court. I've always worked for justice. I've always worked side by side with the judges, deciding what is the best result in every case. My entire career has been dedicated to impartially applying the law in a manner that demonstrates its correct and transparent application. That's what I offer you. And like the other candidates, I have a website that I invite you to visit.
Mr. Collin.
Most people I know ask other people who might know or ought to know how to pick a judge. And that's why I'm so proud of the extensive list of endorsements that I have. In addition to the people I mentioned, every county supervisor, many city council people here in North County, Liz Niss, Joe Huber, Margaret Abe-Koga of Mountain View, Jim Thurber, former mayor of Los Altos, BAMEC, the political arm of the lesbian and gay, bisexual, transgender community, South Bay Labor, as well as La Raza Roundtable, the Vietnamese American Bar Association of Northern California, Asian Pacific Association, Women's Lawyers Committee, and the Republicans in the villages. A wide breadth of people seem to think that I have what it takes. At the top of the list would be the 45 judges and the incumbent. So please check us out, and thank you so much for your interest and your participation in this opportunity.
Thank you all for participating in this forum tonight. And I would like to thank all of you for coming here tonight to learn about the candidates for judge of the Superior Court number 5 in order to make an informed decision when you vote. I'd also like to thank KMVT for taping this forum and for our co-sponsors, the Leagues of Women Voters of Palo Alto and Cupertino-Sunnyvale, and the AAUW of Los Altos Mountain View. And I'd also like to remind everyone that there is literature in the lobby and that you can meet the candidates in the lobby as well. And let's reconvene in 5 minutes with the candidates for the Judge of the Superior Court, office number 7.